Maritime transport service providers penalized for cartelization in India. The Competition Commission of India (CCI) passed its final order on January 20, 2022, imposing penalties against four maritime motor transport companies and their employees for cartelizing in the market of maritime motor transport services on pure car carrier vessels provided to automobile original equipment manufacturers. The OEM have been manufacturing automobiles in India and hiring the maritime transport services of the impugned enterprises for transporting their vehicles at various trade routes abroad from 2009 to 2012. The case was initiated by the CCI based on a leniency application which had provided evidence of collusion among the impugned enterprises in bids quoted to the OEM in global tenders for certain trade routes. It is interesting to note that in the present case, although the CCI had formed its prima facie opinion in 2014 and directed the DG to investigate of the act, the final order was announced by the CCI only in 2022, taking over 8 years for the CCI to conclude its finding. The CCI, noting from the DG report, observed that the ocean shipping industry comprises multiple sectors where various maritime motor vehicles are used for transportation, including bulk carriers, tankers, and vehicle carriers. For the present case, the CCI took the pure car carriers vessel (PCZ) as the relevant market for investigation, which has slightly different configuration from other modes of maritime transportation. In its final order, the CCI noted various evidence in form of deposition or admission, intercompany email, and regular meeting amongst the impugned enterprises for exchanging commercially sensitive price-related information on freight rate for various trade routes, offering joint services, approaching competitors on fixing rate, proximity and close matching of quoted rates in various bids on freight rates or position or schedules, and enforcement of respect rule to avoid competition and protect their businesses through multilateral or bilateral agreement. In the present case, two of the impugned parties had earlier filed joint leniency application in 2016, which was rejected by the CCI, noting that no provision of the Competition Act provide for two or more parties to jointly apply for leniency. Later, the CCI accepted separate leniency application from the two parties. Among the four impugned enterprises, three enterprises and their participant member NYK Line, K Line, MOL, and MNCC benefited from the lesser penalties regulation, where the penalty was reduced by 100%, 50%, and 30% for each enterprise respectively, who fully disclosed, cooperated, and made no attempt to distort evidence during the DG investigation. The CCI directed impugned enterprises to cease and desist, imposing total penalties of approx. INR 63 crores on the three enterprises and 33 responsible employees for contravention of Section 3A, 3C, and 3D Competition Act 2002 dealing with agreement directly or indirectly determining purchase or sale prices, market allocation, and bid rigging or collusive bidding, respectively. Such horizontal agreements are presumed to have an appreciable adverse effect on competition (AAEZ) within India. Interestingly, the CCI dropped the proceeding against three employees individually liable in this case as they were no longer employed, could not be contacted at their registered addresses, and the DG investigation report cannot be therefore served. In respect of the contention by the impugned parties of being an exporter and therefore exempted 3.5 of the Competition Act, the CCI rejected the argument and noted that for fulfilling the condition of an exporter and claiming the exemption, the product manufactured in India should be exported abroad. The Competition Act 2002 exempt from its preview the right of any person to export goods from India to the extent to which the agreement relates exclusively to the production, supply, distribution, or control of goods or services for such export. The CCI further noted that the main activity of the impugned parties in the present case was to provide maritime transport services to the OEM. The CCI further noted that limited exemption has been provided to the exporters of the goods or services under the Competition Act, and any cartels entered for the supply of any input goods or services may be protected and exempted 3.5 of the Competition Act when the ultimate good is being exported abroad. Such an exemption has been granted to develop India's export and develop as a manufacturing hub. Furthermore, concerning the contention that as the ultimate consumer is located abroad and the activities among the impugned enterprises hadn't caused any AAEZ in the Indian market, and therefore the CCI would not have the jurisdiction over the case, the CCI again rejected the contention and noted that the Competition Act provides no differentiation between ultimate consumer and immediate consumer based on where the goods or services are used as an input in the value chain. The CCI noted that OEM located in India would constitute as the consumer, and therefore the activities of the impugned parties tended to cause an AAAC over the Indian market. Separately, on vessel sharing agreement (VSA) being earlier exempted from the preview of the Competition Act, the CCI noted that such VSA exemption itself created a carpet for agreement resulting in concerted practices such as price fixing, limiting capacity or sales, market or customer allocation, and bid rigging or collusive bidding. In addition, the CCI noted the press release by the Ministry of Shipping giving clarification to the industry, which also mentioned that vessel sharing agreements are meant to promote ease of doing business in the liner shipping industry. Best practices consist of not indulging in anti-competition practices, which include price fixing, imitating capacity or sale, and market customer allocation. It is interesting to note that vessel sharing agreements in the liner shipping industry were earlier exempted by the Ministry of Corporate Affairs (MCA) from the scrutiny of the SSE, and such exemption, VSA exemption, ended only for July 2021. Thank you.